Mr. Mazurmiya, we'll pass the orders after there are some old criminal matters. We'll go through that and we'll pass the orders. The chambers. Kanungo was also appointed. Just go through the file. We'll just go through the file. We'll see what file to deduct. Item number 41. Keep him. What are your items? No. They're back. 37. That we will pass after the. We need not wait for that. You are for?
Seven, my lord. One book I want to rely on. How, my lord, it is to.
No, that way, if you want to make some submission, get Mr. Decca also.
Oh, my lord, only law part.
No. We will not hear that because we have concluded it. No, doesn't look nice.
Only law part, my lord.
You get Mr. Decca, we are here. Heavy rain. Oh, dictation did you? I have some pending matters. We'll just see that and then come back. Can't help it. Yeah. If somebody comes, Jodi ahe mung material mo aijo. No. I understand because when I came in our area, there was water. So I can understand that. Mr. Decca, Mr. What do you call that? Barvia's submissions doesn't seem to be ending. He has made a fervent request today morning that he wants to make one more submission. I said, I'll not hear it in your absence. What is it? Where is he? We'll have it at 2 o'clock. Today it's ending. I can't carry this matter, read it daily. Today it's ending, don't worry. Either way, you get him, 2 o'clock.
No point. I'm sorry, my lord. Before that, mentioning item number 51, my lord. My lord.
Just
Extremely before mentioning this on Friday, my lord. If it is inconvenient to your lordship.
Mr. Das, this is with regard to that railway properties. I've gone through it. Matters are there. There is evidence against you. Recovery is made against you. There is nothing brought on record by you. The only factor which is, otherwise I could have gone for that probation thing for you. But the only thing that is hindering me is, this is your second offense. And under the Railway Act, it's a serious one.
In that only conviction is 3 months, my lord, only.
Be that as it may. Be that as it may, but this is your second offense.
Second.
So in that view of the matter, and it's not alternative, it's together, along with fine. So if it was either or, I could have limited it to fine also, because of the time frame. So if you can just give me something on that, I'll try to do something.
It will be on Friday, my lord.
Thursday, if not otherwise. Okay. On okay. On the prayer of Mr. N.C. Das, learned senior counsel, appearing for the petitioner, who submits that the matter be taken up on Friday, a Friday date to review, or final consideration on a final consideration. Prayer is not objected to by the Learned Council for the DKD Learned Council, Standing Council Railways. Accordingly, register to list this matter again on Friday as a top of the list item.
As it will take some.
Domestic gas cylinder. No. Yours is that
Start back, my lord.
Ascot Bank.
I'll show your lordship.
This is the second case.
That has been
No.
acquitted.
Second case
Second case acquitted. my lord.
wherein the advisor is involved, but advisor is acquitted.
So one
And the
will be
other
paid-
person is brought to the dock and done away with. Earlier was one Mukabir. Mr. Kotoki had appeared. No, I don't know. Mr. Chaudhary had appeared. And today is this. We'll do it. There is no problem. We are ready.
The thing is that for today,
Mr. Kamar, if I can hear Mr. Kamar for the whole day, it will
No,
be a
no, no.
blessing for this group.
I'll have to also go through it. I'm just asking for today's accommodation because I was taken by surprise. Consider Thursday, I'll do it, my lord.
You are under 420B. And Mr. Kamar,
There will be two private.
there will be the submissions before the learned trial court. Everybody had put it on. Okay.
I'll just put two things, my lord, for your lordship's kind
Mm, mm.
consideration.
Mm.
Preliminary, whether a person who was a public servant has been acquitted, whether a non-public servant can be under the IPC simply that type of situation.
That's an arguable point.
Then second, when there was a
What will happen, Mr.
there are
Kamar?
judgments, my lord, he cannot pass that argument.
Mr. Kamar, say a case is registered wherein one public servant is involved and there are other private parties. So against this Public Servant Prevention of Corruption Act and all those things come in. Now, he is acquitted. He is acquitted for whatever reason.
So whatsoever.
Whatever reason. I find that it's a very, there were materials. But anyway.
But I'm just, lordship is so much interested. Appa's case against me, of course, but that is in the context of framing charge. But here, the person has been fully together under the joint conspiracy. So both there was prior meeting of.
Now, what about my confusion is, now in the last stage, this is in the last stage that this conclusion has come. Now, whether the special judge can take say that I'll not decide this matter any further, let it go before the
think
normal court.
That will be my submission. It is for the magistrate.
Is there any
Yes,
decision of the Supreme Court?
I'll try to impress upon your law. And the second most important factor, when there is a joint prior meeting of two minds. If one goes,
The meeting goes, but because he has not been convicted under 120B.
he cannot
not
be
convicted.
to convict under
There
120.
will be two persons. So that charge is gone. He is only 420.
Only 420 remains. Whether my part is that cheating and whether I have simplicitous cheating, or I conspired with somebody and cheated the bank. That will fall.
You mean to say that if it is found that there is no involvement of the public servant,
Then I am going.
the special judge's jurisdiction goes.
One thing, and under 120B, my whole charge was that you conspired with the public servant.
There is no ground taken by you in the appeal memo, I suppose.
I have taken, I have not gone through it. But facts remains, my lord. Law points can be raised at any time, my lord. All respect, that's why it
Okay,
will be an
Thursday.
interesting part. Let's see, I
Madam.
have given my judgment against going.
What
against
would be your take on this, ma'am?
what I have submitted court.
You just examine that issue.
I have given a judgment which goes against me, but that is in a bit
That
different.
much we expect from Mr. Kamar.
I'll with them. Nalappa, my lord, I'll give the side.
For criminal conspiracy, madam, will not more than one mind be required. But you did not file an appeal against the acquittal of the main man,
A public
the
servant.
public servant. Why? Why an appeal is not being filed?
Take instruction.
I find in this case, in the earlier one also, the other one also. Man, get that instructions.
Your lordship has taken so much. All this, we are reading only one case, my lord.
No. Let's say, Mr. Kamar, this is a new thing for me. It's an interest. I'm trying.
Try to impress.
Heard Mr. Z. Kamar, learned senior counsel, assisted by Mr. P. Roy Chaudhary. Dave Chaudhary. Made a mistake. Dave Chaudhary, learned counsel for the appellant. Also heard Ms. M. Kumari, learned standing counsel, CBI. So, as prayed for by the learned counsel for the parties, a registry to list this matter again on Thursday. 18/9. If you can, if there are some judgments, if you can just give the citations tomorrow. Mr. Dev Chaudhary, you give the citations.
Sure, my lord. Tonight I will look for it and give
Uh,
it to you.
File to
Likewise,
veto.
I'll give it, my lord.
File to veto from my review.
Much more.
Sure, ma'am. I'm thankful for that. Yes,
Your Lordship,
Thursday. Oh, Mr. Kamar, madam has some problem on Thursday.
I did, my
letter at Delhi.
When do you want?
Thursday and Friday,
Then we'll have it on Tuesday. 23.
that will do it. Good man.
Yes, madam.
I want to mention regarding 44 of daily. Next week, any date may be.
Oh, you be here. You be here, read the file, 3 colors. You go through the file, the drugs, na? 3 colors, and also see the evidence of the private parties, the villagers who were there, when the seizure was made. Just go through these 2 points and come back. Then we'll ask Mr. the PP. Just go through these 2 points. Yeah.
Item 30.
Now,
Item 39.
go for item number 39. Who is for item number 39? Oh, you are for the main man.
Yes, I am for the main one.
But during the trial, the submission of the learned counsel was the others are not to be brought in. It's only you who was responsible. It's not in one place. In 2-3 places, the submission finds. What do you say on that? You have not taken any ground with regard to that. That judgment, it's clear that you are, forget the conclusions, it's the submission. But you have not taken any ground on that. Everything clearly.
Petition also there, my lord.
Confession is an extrajudicial one before the officer.
officers.
But those officers came and deposed that he made this confession before us.
Subsequently, he has taken the plea, my lord. That
That's your subsequent plea that was taken, but those materials that are there, you did not cross them to that effect. Basically, it is admitted position that you were the deputy general manager and accountant 3. And you were the man who was receiving the codes. Once you have received the codes, it was your duty to assign it to the particular account. You did not do it. To that extent, it is admitted position. That materials are sufficient. Now comes the question of you opening an account in favor of your wife, both in your branch and in UCO Bank. And the transactions made therein, which is the money which is to be deposited, which was to be deposited with the state bank, the AACB account. 1. That is color. Then the next is, first is color printers. A2. Therein, everything is done by you. Opening of the account, transaction. Only the specimen card signature is of P2. A2, sorry. A3, again, you. A4, he is a man who was working at that relevant point of time as a cashier in Bank of Baroda, nephew, Prague agency. He says, I have got nothing to do with this. This is my uncle. So, Mr. Chaudhary, now tell me what are the things you want to highlight to dislodge this?
Case for me, my
Understand? That is why Mr. Chaudhary is here.
problem is that my
Hope what I have understood is,
Yes,
this
yes.
is just what
Yeah.
I have just, it's tentative.
yes, yes.
Yes.
For me, for my lord to argue for the
You have, there also you have only prayed for a lenient view. Probation of Offenders Act, I'm sorry, will not apply in your case.
there will be before lordship my
80.
7980. Certain statement. (13.1), my lord. 13.1D.
Hmm.
Other offenses, my lord, that
And the learned trial court has gone with a shortcut method. They each are similarly sentenced under 120B. What is this writing?
I see, my lord,
No, it's not that. If you can come to page 23, internal page 16 of the judgment.
no. That is, my lord.
Huh.
In the result,
No. The conviction part, sentencing part.
yes, my lord. All the four
Who
accused
convicts-
are liable accordingly.
No, liable account, forget that. Come down. 1.
The four convicts are
So-and-so, so-and-so.
individually heard.
The next paragraph.
The fourth convicts, so,
Each.
and each sentence to RI for 3 years with
Under so-and-so in default.
ITC in default payment.
Then next one, they are each similarly sentenced under so-and-so. We'll have to draw the conclusion that this similar is this. Okay, he understood that.
Yes,
But he did not have the time to specify that. And you come down again.
yes, my lord.
Convict, is also similarly sentenced under 468. And then he says, okay, fine. Now tell me how? How can I be of any help here?
Bad case, my lord.
We understand. And I'm Mr. I expect that from Mr. Chaudhary also,
Because
that he is fair. We know.
In argument itself, my lord, we have
Said
in
that.
trial court only, my lord. They have taken that plea, my lord.
And the person who had taken the plea, we know, we can feel what the merit of the matter is.
My lord, I am only praying, my lord, considering is, my lord, whether the punishment of the.
What can be the, now it's maximum 5 years.
Yes. Now it is 4 years, my lord. At that time, it was 3 years.
How long was he in detention?
To see the.
Just check. The minimum period is for 113 was 3 years. 1 year. That time it was 1 year.
Subsequently, it was 3 years. Now it is 4 years, my lord.
So at the time when the offense was
Committed, my lord.
committed, it was 1 year. Can you just get that thing from me?
Yeah, who don't need to answer.
Hmm.
Yes, my lord, 1 year.
1 year.
Any public servant who commits criminal misconduct shall be punishable with imprisonment for a term which shall not be less,
7 years.
shall also be liable to.
So minimum 1 year you will have to. That cannot be.
He cannot, my lord, pray.
It cannot be. I can that not,
Yes.
my hands are also tied. Then what about 420?
20, my lord, there is no such minimum.
Okay. Now, Mr. Chaudhary, Mr. Chaudhary, one query. Now, the amounts are fixed, 10,000, 50,000, be that as it may. Now, if this court feels that, okay, we are giving you a lower sentencing with regard to imprisonment, can this court increase the fine amount?
Here, my lord, no.
No. For this court, just a query. Can this court enhance that? Because normally if I have to enhance the imprisonment, I'll have to give you notice. What is the situation with regard to fine? Is it the same parameters? Enhance it. To the modification of that.
6, my lord, there are. CRPC 386.
Wait. Because the pendency of the matter for such a long time
Yes,
is
ma'am.
also, we find that it's not,
Over he has lost his job also, my.
that is a natural corollary.
Yes, my lord.
That should have happened. But I appreciate the ingenuity of his thought process. See,
What is the finding and sent with the teachers that is not there, altered.
no, it will be B in your case. 386B. In an appeal from a conviction. 3.
Reverse the finding and sentence and alter the finding, maintaining the sentence. Without altering the finding.
So what would be, whether it will also be involving that fine part?
Fine part is also there, my lord. There, my lord, that is there, that it can be enhanced, my lord.
Anything?
Sentence. Up clause 3. Or without altering the finding, all as to enhance or
No, this is in an appeal for enhancement of
enhancement
sentence.
of sentence.
This will not come in your case. Yours is an appeal against conviction.
Against conviction.
Because I'll have to give, if I have to do anything, sentence. Is the word sentence somewhere defined? What do you mean by a sentence?
Sentence, my lord, comes to the
Fine.
fine mind.
Okay,
Both
got it.
comes.
Got it. And. Or it will be that. Okay, got it. So, Mr. Chaudhary, we will record that you have only made your submissions with regard to the sentencing. Mr. B.M. Chaudhary, Learned Counsel for the petitioner. Madam, nothing to say on this?
I'm sorry.
But Mr. B.M. Chaudhary, Learned Counsel for the petitioner, also heard M. Kumari, Learned Counsel, appearing for the Learned Standing Counsel, CBI. Mr. B.M. Chaudhary at the outset has submitted that he would not assail the impugned judgment, the conviction of the appellant herein by the special judge CBI, by the impugned judgment. Also, he proceeds to submit that the appellant herein is presently aged around 80 years and is suffering from old age ailments. Also, accordingly, he submits that the sentencing of the appellant by the learned trial court would require a reconsideration, more so considering the lapse of time since the date of commission of the offense involved in the proceedings. Also, he submits that the appellant herein had undergone detention for dash. Just
I will just
ask your
check it,
junior
madam.
just to find that. Please. So accordingly, he submits that this court, in exercise of its power of appeal, be pleased to modify the sentencing of the appellant herein. Also, the above is objected to by Ms. M. Kumari, Learned Standing Counsel, submits that considering the nature of the offense established against the appellant herein, the learned trial court had already taken a lenient view in the matter, and the same not mandate any review by this court in exercise of its appellate powers, appellate jurisdiction. Also, she further submits that in economic offenses like the one involved in the present proceedings, the accused is to be quickly is to be punished. Punished with severe punishment so as to restrain commission of such offences in future. I've heard the Learning Council for the parties also raised to list this matter on Monday for delivery of orders. Just give me that breakup.
Sir, in the section, my lord.
Oh. The other cases, I don't think so it will be required, but for your this period of detention, maybe. No, 38 to 38 to due.
Wife and the
Wife.
nephew, wife and the.
Eight.
Wife is concerned, one transaction was there. Amount of rupees 26,000 that was entered in her.
8 A
A3,
3.
A3. The charge you also will find, only
A3?
one amount is entered in her
And A4.
and A4. Probably you also will kindly see. Amount of 26,000 in her account on 18/1.
Mota. Kata here. Yes, page
Page 2.
2.
That is the charge. Charge it has been alleged that in the middle portion you also will find on 18/190 UA.
Madam, you can have your seat.
The middle portion also will find on 18/190 UA1 credited rupees 26,000 in the account number C295360 of your wife, maintainer SBI New Guwahati branch, by diverting the funds of ACB. Also opened one account A627, that is of the Prasanda Kumar Das, Messrs. The name of A4 as proprietor of Prague agencies has credited 12 lakhs 19,170. So far wife is concerned 26,000. And so far this Prague agency is concerned, 12 lakhs 19,177 was credited in the account of Prague agency. Basically, that is the allegation. (120B), then again same allegation under 420.
So 420 and 120B, 26,000 and 12 lakh 19,000.
19,177. So
Then
far Prague agency is concerned, and that too it was transferred from the account of color printers. First he opened the account of color printers, where he diverted the amount of the ACB. Thereafter, from that color printers, it was sent credited to Prague agency. 12 lakhs amount.
Then 120B,
120 same allegation.
468 is with regard to that,
468 is not there.
not there,
Only 420 and 120.
120.
Evidence of witnesses which have come then, only 26. And so far Prague agency is concerned, it has come from the evidence of the prosecution witnesses that it was run by Kovinak.
Hmm.
Only by name it was there. Everything money, every dealing was done by Kovinak. That you will also come W39, you will find.
Has put the signature.
He has put the signature,
He has the knowledge.
knowledge is the different, but everything was done by Kovinak.
Just give me 2 minutes. Okay.
Is 98.
PW 13, PW
40.
40.
40, page 98. During the period between 1990 and 93, I was working as salesman cum office assistant in Messrs. Prague Agency. The Prasanta Kumar Das, A4, alias Tanku, nephew accused Sri Kovinak, was the proprietor of Prague in paper. But actually, this farm was financed and run by accused Sri Kovinak at Tanku. Sri Kovinak was an employee SBI New Guwahati branch. Only prosecution witnesses, papers only my name was there. Otherwise, everything was run by Kovinak. That he has admitted in 313 also. There was no conspiracy. Whatever he has done on his own. So it has come from the witness that
He was an employee.
he was an employee. Everything.
This aspect was taken care of by the learned trial court.
Then also the conspiracy. There are
What do you have to say about the A3? We'll come to A4 subsequently. A3.
A3 is because his
The
wife
charge is one, but the allegations are that you had two accounts in UCO Bank and you
Money
were
is
an
there.
employee of UCO Bank.
was an employee.
So you cannot deny knowledge of
But
the
that-
transaction, and lakhs were transacted from that amount.
Yeah, not in the UCO.
No. But the evidence that has come on record, the money transaction was found also in the
No,
UCO
not from this account. Only-
there was transaction. There was a plot of land also brought
Land purchased in her name.
in her
That
name,
month-
but
after
the
taking loan, it was purchased.
that material, where, show me.
That your lordship will kindly see. In the charge, it is not there.
Charge it is not there, but the evidences have come.
Evidence I will tell, lordship. And it was purchased from
Land is there and the UCO bank.
in the UK bank.
And in your
But that is not
313,
connected with this.
and in your
Case,
313,
lordship.
in your 313, you have not denied this.
But he has stated, Govina has stated,
Admitted.
yes, she has admitted as because it was purchased in her name.
No,
It
no,
was
the
purchased by her husband.
transactions in your account. Come to 313 of the A3.
On in A3, just a minute. I think purchase, there must be something in the procedure of crime. Because that is regarding purchase, it will not come
That show me, Mr. Taludar.
on eternal.
Or can you do one small thing for me?
You kindly see first Govina's 313 statement, 141 page.
41.
The number 139. Here he has stated, Govina has stated, I mean,
Yeah, that is fine.
when he said, I
because
have
the
diverted
knowledge-
in an
that is-
account
that
without
is-
her knowledge.
That is the love and the care of a husband. Is a very good husband.
Amount is also less, that's why she may not be aware.
Amount less or is thing nothing. She is also a banker.
Bank account, in a different bank.
Where is her 313?
That I am coming. Page 150 onwards.
150.
That question number 6, your lordship, that's what I was saying. W37 also says that exhibit 334, Dipan Ghosal and his family members sold the land at Ulubai to you. What is your say? Yes, the land was purchased by my husband.
Where is the loan?
That it will come. W37, your lordship, will kindly see.
Just so. W37.
36. Pan Ghosal.
That is that land thing.
And regarding the line, is 90. During 1992, I had an electronic contract firm under so-and-so. My family consists of 4 members. They are my mother, so-and-so. We have a plot of land measuring 1 kotha per 5 lesser situated at Ulubari Moja, covered by patta number so. The plot of land was sold by all our family members to Nag, wife of Kabir Nag, and such sale was executed on 10/4/92. It was sold for rupees 48,000. Exhibit so-and-so is the said sale deed and so-and-so. At the signature Srimati. The Kabir Nag was working in SBI Guwahati during that time. The amount of 48,000 was paid in cash. The amount aforesaid was paid by Kovirnak on behalf of vendor.
Kindly go further.
Mrs. Antanak, one of NK Singh, was the mediator in effecting the sale deed between the parties. The check 139 is in my favor for an amount of 50,000, but Mr. Kovirnak gave the check to me in my favor. It was given by Kovirnak. The said check was issued by Messrs. Color Printers. The amount of the check was given to me for the grassroots of the plot, so and so, so and so. Another amount was given.
No,
for
where
the
is that material to show that this is in pursuance to a loan? Because the transaction is by cash.
by cash. But that is, he has clearly stated it was paid by Kovirnak on behalf of the
Treat it as it
vendor.
may, whether you knew about it or not. The land is coming in your name.
Lordship.
So the meeting of
Nowadays,
minds.
we also purchase land in.
No. We can, but the meeting of mind and the
That-
money is being
that-
given from color printers.
That,
So that
with-
proceeds of crime is
that
coming.
with my humble submission, that has not come from the evidence. I had the knowledge. It has come from, the money has come, because he has paid in cash. Not that it was the check of color printers or Prague agency.
Subsequent is from color printers.
That is for development purpose, not in my name. That is for a development.
But she does not say in a 313, although a specific question was made, that this money is from loan. She does not say that.
And that's it, sir. But
Ah.
he said that her husband purchased in her name. What is there? And that has been established by the prosecution witness itself. Because this witness has clearly stated Kovirnak made the payment and it was paid in cash. So far purchase is concerned. The rest, that check was for development purpose.
Okay. What do you say about the conclusions reached by the learned trial court with regard to your involvement?
You'll also will kindly see that finding is also wrong. Is 185 you'll also will kindly see.
Hmm.
So far Anjal Nag is concerned. Para 3. What I have found from the foregoing materials is that A3,
Page.
page 185. There are two onwards, Your Lordship. Our learned counsel James Chaudhary contended everything was done by her husband A1, who obtained her signatures, and only at his behest she had to put her signatures whenever required, including the transaction made for the land purchased by A1 in her name,
So this
And-
is the submission made by you.
made by James
Hmm.
Chaudhary, made by us.
Then-
A3 had no consequence diverting the money by A1 or in the sitting in question.
What I have found from
What I have found from the foregoing material is that A3 had as many as 3 bank accounts in her name, out of which one has been operated in the NG branch, transacting money diverted by A1 from the account of color printers. As aforesaid, while another account lying in the UCO bank was also being operated with such
such-
money in respect of the amounts of such money being transacted. Though he said 2 accounts A3 of the A3, it remains that there was full knowledge and acquiescence on the part of the A3 in the operation of those 2 accounts of hers, for the simple reason that she had happened to be an employee of UCO bank. It is hence not at all believable that she had no occasion to go through her 2 passbooks standing against the said 2 incriminating accounts respectively. Moreover, she had
this
to-
is important.
that is important. Now, lots will come below. Moreover, she had to sign on each and every acquisition of transaction so and so. Accordingly, it can be inferred that a concern connivance in operating so and so, so and so. Now, the last para, as lakhs of rupees were being transferred by A1 through the said 2 accounts. Where is the lakhs? What is the allegation in the charge? 26,000. How come lakhs will come? Though he said she has presumed to have been in a known source of money coming out of their favor, and there might have been something more than more mere transmission of their thought, sharing the unlawful design so and so. So she has been convicted. If you go by the charge, only allegation of one amount, 26,000. Here the learned trial court has come to a fine. Some rupees have been transacted. Knows, I have induced whom? Where is the inducement? That inducement has not been. Must induce somebody. for 120B and 4. Of the evidence laid by the prosecution.
Okay.
Charge framed against her. For A4 is concerned, on papers his name is there. His rest everything was done by COVID-19. The prosecution witness
Can we have the 313 of
this Prasanta. Page 153, Prasanta. The answer is that question number 1 itself. W28 Pavitra Boro during a cashier so-and-so check of 40,000. Payment of the said check was made by, he also stated you received the payment of check so-and-so. I cannot say as COVID looks after the firm. Straight away from his defense is that everything, whatever it was done by COVID-19. And question 6 you'll also find answer. Only my name is shown as a proprietor, but it was formed by COVID in my name, and he used to look after day-to-day business and he dealt with me. And question 8, I cannot say as COVID used to look after business. And same. Regarding operation question 13. Yes, COVID actually operated the farm and the farm was formed in my name. I have never conspired with COVID to misappropriate any money. As I was his relative, opened one farm.
Okay, Mr. Talda. So your case is that insofar as A3 and A4 are concerned, the transactions involved are at the behest of A1 without any reference to them. So the criminal conspiracy also is not there. 420
is
also,
also not there.
Mr. Talda, I would appreciate if you can give me a written argument wherein you bring in all the evidences which are in your favor and deal with the conclusions of the trial court. And any judgment if you want to. How long will it take for you? You can give me by Monday. Because Monday we are having the other matter. So if you can give me by Friday, I can pass the orders on Monday. Yes, madam. P4. A4. What is your material to establish that? W30.
Whatever it is said, it is
It's meeting of minds.
Mr.
Madam, is there any evidence on record to show that the proprietorship was not in name, not in paper, but also in fact? And say he has given some income tax returns, because this things materials that he is the proprietor, the earning is by him. Is there any material? Because he's the proprietor, he's also the owner of that complex. But is there any material other than this indirect thing directly?
Have to go through the.
You go through it, give me a written note. No need. No need. But he is having a proprietorship firm, so he will have to have a
Admitting that it is
admitted. So whether that income that was generated from there, where was it channelized to? Have you found that channel? He will have a balance sheet. How is this balance sheet being maintained? No, balance sheet, proprietorship from balance sheet would be there. Check up whether your officers have also gone in that line. PW40. Madam, you just go through that, give me a small note. Madam, you give me a note on that. We have got your point. Give me a note on that. You can give it to me by Monday. I'll be appreciable. Next, Aru, item number 40.
I believe it.
Hmm.
Yes, my lord. Stand taken by the appellant, my lord, is Govinak, my lord. That he was operating the farm, my lord. The signatures appearing in the specimen signatures of the color printers that has not been proved because I never visited the bank. Else who have introduced me, I said, we never know this person Govinak.
The officers say that they have introduced your signature on the persuasion made by Kabir Nag.
Govinak himself said that he was operating that said color printer. So it is in the name of. He wants to say he is one of the proprietors of that farm. Of that stand taken by the appellant, my lord. Cannot be a case of conspiracy, my lord. Hired with Govinak for operating the account, my lord. What he has done, but whatever money that has been collected.
But you had denied your signatures, but that was again proved by the
And
the court itself went into the issue and compared.
Yes, sir. That comparison, yes, I have denied it. That I understand, my lord. Technical part, that is a part, but factually, my lord, from the evidence, it is found that I never visited the bank. Full account was operated.
The bank employee could not recognize you.
And because
And it was,
that is it. And he has also admitted that it was operated by him, my lord. all the accounts, the transactions were operated by him, then where is the question of conspiracy, my?
Not getting that. Some missing link is there in the submissions. I want that. It's not coming. It's not been very emphatic.
I understand why. Because your lordship will keep, the finding of the court is that except the handwriting expert, there was no. Court has come to finding because that handwriting expert opinion is that some of the signatures in the
It has connected the evidences.
that's what I
That chain is there.
understand. No, that chain I understand, my lord. Because regarding operation of the accounts, he says it is a fictitious account. Pinang has taken a plea, it is a fictitious account.
No, the firm is not there.
Firm is not. So it is a fictitious
It's a fictitious firm.
account. So if that is the fictitious, so it is not operating as such, it doesn't have an office of his own, nothing that. So in papers only the account form is there.
Let us see your 313,
313, my lord.
your explanation.
For page 144, my lord. I have given, I know account number so and so, there we have denied him. I do not.
Come to question 27. To say that this is a fictitious firm, that there is nothing, but you read this.
But yes, he says that
I'm a partner of, so
I did not operate.
you are a partner in a fictitious firm.
Yes, that line is there, my lord.
That is your clarification. So this line undermines what you have built up.
But fact remains that when it is a proprietorship firm, cannot be two partners. Is that one you and
No, the proprietor is you, but the backdoor operator is Mr. Kabir Nag.
Of course.
So that you are accepting the legality of the firm. There cannot be two proprietors in a proprietorship firm.
I understand, my lord.
You are the proprietor. Mr. Nag has never said that he is the proprietor.
He says, but
He says, I am the operator.
no, he was also one of the proprietor, my lord.
That cannot be accepted.
The PW 34 says, my lord. It says that you and Kobinag were the proprietors of color printers. So that has come from the mouth of PW 34, my lord. Yes, there is evidence authorized on the account of a firm in the name of color printers. So that has come from the bank witness, my lord. Yeah.
But he did not recognize Jikedas in the dock. That's that bank employee. Okay. Mr. We have got it. You also give me a detailed note with dealing with the conclusions reached by the
So
learned.
basically, by my case is about conspiracy. Whether I conspired with
So if conspiracy goes, the other part will take 420 will take care of
take
itself.
care of. Yes.
So just give us a written note on that.
Yes, conspiracy part.
Monday? Madam, on Monday, each individual thing, don't give me a amalgamated one.
Last occasion I have given.
Don't give me together, give me individual,
Yes,
because
please.
these things have to be individually dealt with. And Mr. Chaudhary, record ahil nigi? What do you say? You can ask your juniors to make that checkup and just give me that breakup. So let's see if we can do something for you there. But 18 item number 39 to Belekki Disuno. Baki 38, 40, 38 and 40. Huh? Heard the learned counsel for the parties at length. So, hearing remains inconclusive. So, registry to list this matter again on Monday. I go to Monday, Dishuna? Monday. Along with criminal appeal number 125, 2008. On Monday, Mr. Talda, Mr. Puragi, just give me a small note. Okay, done. It's a new thing for me, so some questions may be very nonsensical. Please don't mind it. Yes, what have you got? You are 40, wife 40, husband? Wife, okay.
A good case, this is
Go for 127, not in this proceeding.
should be 1,000 rupees for
Ah,
three
that
people.
is different. But he has questioned your morality,
Judgment.
dealt with. That is not established. And he has also dealt that you have not established the sister-in-law relationship.
This is regarding 125, Lordship.
Those things are immaterial.
Lordship.
Marriage is proved, paternity of the child is proved. So the money should flow.
The income of the husband is
Is
also
also-
established.
Yes, what do you say, Mr. Govind? What do you say about the your income?
He working on the
You have read the evidence of the wife. You have not crossed the. Mr. N.J. Gogoi, learned counsel for the petitioner. Amicus curiae appearing for the petitioner and Ms. G.S. Kanungo, learned amicus curiae appearing for the respondent. Hearing concluded. But full stop. बस ये तो खाली लिखी मुक judgment duta was at 2 o'clock. Yes, Mr. Mandal.
I'm extremely sorry, my lord. This case, my lord, my senior counsel here will, my lord, address. And today he has some personal.
You, I'm not adjourning this matter on any count. Take the file, argue. PW2, how you can demolish it, come back and here.
Two, my lord.
Two, no problem. But it will not go beyond this date. PW2 only you have to say. And 328. 328, what are the ingredients? Whether that has been satisfied. That much only. Yes, Mr. Burwa. 328 here is satisfied by IPC report.
Eyewitness, my lord.
That is the main problem. You read her evidence once more. The handwriting is poor. Somehow we could get through. 328. Now here, 328 is the use of poison either to cause harm or to commit an offense. The charge sheet that was filed is the administration was with regard to the poison was with regard to committing of that offense, because there is an allegation, there is a deposition of PW1 and PW2 that he had come in the night and inquired whether they had taken their food or not. 2 and 3. So they have that evidence is there. Now that is only with regard to commission of that theft. Theft, nobody has seen them committing it. Unconscious. Now, theft, the learned trial court has not accepted. It has acquitted the other 2 co-accused who were said to be involved with the... now, whether 328 under such circumstances can be said to be established. Just examine that. We'll take it up at 2 o'clock. Get my point? So here your prosecution story is that he had put that poison there, made them unconscious to commit that theft. So it's not to cause harm. It's to cause the theft. That's not been established. Just go through it. File to DD. 2 o'clock. তাতে চাব দিয়ক না ছেকশ্যনত চাব দিয়া ইয়াত এক ঠেলা আছে ইয়াত নালাগে তাত আছে কৈ দিলে হ'ল মই কোৱা বুলি ক'লে হ'ল তাত চাব দিছে বিফৰ দি এইটো অৰ্ডাৰ কৰি দিম মই এইটো অৰ্ডাৰ কৰি দিম None has appeared for the appellant on call. Mr. Ajay Burwa, learned public prosecutor, is present. Ms. Nanda, one amicus curiae for the appellant. Can you appear? Ms. Nanda, learned counsel of this court, on being requested, has consented to act as the amicus curiae in the matter. Full stop. Courtmaster to furnish a copy of the appeal memo along with its enclosures to you, Nanda, during the course of the DRA photocopy kori at a DD bode. Registry to list this matter on Thursday. Thursday. Thursday date to DD. It's a case wherein an allegation is against the accused that he had made a forged general power of attorney and drew money from the government pertaining to one contractor. Evidence on record shows that the power of attorney was made in March, whereas in the same year, February, the contractor passed away. Then he developed a story that he had made this payment to the wife, but the court has not believed it. So try something you can work out. He'll give you a copy Thursday. Thursday, reflecting the name of Miss Nanda, amicus curiae in the matter. Okay, Mr. Burwa? Yes, Mr. Vishwas. It's nice to have you.
But your lordship will not consider my prayer.
I'm sorry, 2013 matters.
Suddenly matter appear, we cannot. Your lordship know I have got so many 17, 18 cases every day. I cannot appear.
We are trying to do something with your cooperation.
My lord, in this case, my lord, it is a case of 21A of NDPS Act.
To divorce. Have you gone through the record?
Lordship.
And my lord, there are 6 witnesses. And my lord, the story is that these 3 persons were coming and they wanted to enter to in a meeting.
Mr. Vishwas, have you gone through the evidences? You have the evidences with you?
For the evidence, my lord.
Evidence ki dadi hoksam.
I'll
We'll cut the matter short, don't worry. Evidence ki dadi. There was an allegation that 2 persons, one ran away, one Salam ran away.
Exactly.
2 persons were coming to the village. The villagers, because they were said to be intoxicated by drugs.
Yes, exactly.
So the villagers caught them and they inform the police.
Yes.
The police comes. Additional SP also comes. And the seizure is made. The seizure memo says a gray color material, powder
Exactly.
was cracked.
Aye.
Then it's sent for GD entry is made, sent for your forensic positive brown color,
Brown color.
right? Comes back, FIR is lodged, the offense report is made, cognizance taken. Now the point, whether you have seen it or not, if you come to the evidence of the PW, this is what I wanted to ask Mr. Goswami.
From whom it is seized?
No, that is immaterial. It is seized from both of you.
But how can you one packet?
Forget
One
it.
packet, how can you?
This is drugs. We are not going to that level. There is something else which I want to get a clarification. There is the evidences. You have the evidence of PW1.
Yes, yes.
Come to the first paragraph. If I think this is the first page.
Yes.
Police took both the persons.
Yes.
Huh?
Yes.
Just read that. Police took both the persons with them.
Mother
Powder
and we have been improperly under the influence of drug.
Hmm.
They were from other village,
Hmm.
ceremonially of our village. Both of the word of them, the villagers present tried to caught hold of them, but ceremonially fled away.
Hmm.
The villagers caught hold of 2 persons. Police was informed. Police took 2 persons with them. Like a powder, like substance was recovered from them as told by police. Police asked me not to put my signature on the paper envelope and seal envelope where exhibit 1 is my signature given as witness. The 2 unknown persons are the accused persons present in the dock today. I do not know their name. Now, if it cross my police called me to
Now this is important.
called me to bazaar following day and allowed me to put my
and showed me the
powder. I did not see police searching the body of any of the accused, which is very
Mr.
mandatory.
Bishwas, Mr. Goswami, please also say. The recovery was made on the night of the day of occasion.
Following day it was
Following day, it was again broad day. And now you come to PW2.
W2, my lord, yes.
To the second line starting outside.
I was
villagers.
on the hotel
You can
bazaar.
read that. You can come. The villagers asked the accused. Villagers asked the accused as to their identification with one of the accused, a packet containing yellowish powder.
Yellowish powder. Again, yellowish.
Now read. Police was
found.
informed.
Police
After
was
20
informed.
minutes came. CI OS Borderpur PS came. Villagers collected. Police took the materials. Police took the accused and also the materials found with them. Now you read.
Yes. On the
following day,
next day.
police and additional SP came to the place.
Yes.
So here,
Yes.
the seizure memo, 6-9
With them.
additional SP signature is there.
Yes.
But your witness says next day additional SP came.
So, my lord, whole case gone on this point.
What is more
Whole
to be
seizure
done?
is illegal, my lord.
That part I have seen, my lord.
What more is here?
That you
The 3 colors of a same drug
lost.
not taken into consideration by the, because colors we would have not had any problem, provided the seizure was made on the same day and it was completed on that day.
Exactly.
Here the powder remained with the police. What happened? No
Yes,
explanation.
exactly what happened. We do not know.
Yes, ma'am.
And
But
moreover, the sample was sent by the additional SP without producing to the court. He said, I do not know whether it was produced to the court. Can he?
The extraction has to be made in the court.
Yes.
yes, ma'am.
Then it has to be sent. It
Yes.
was sent directly.
Direct.
And the other part was sent in the, kept in the police station.
Police.
God knows. Anything more?
Yes, ma'am. I am coming to cross part, my lord. That what is the cross, my lord?
Okay, ma'am. We are open. Okay. What is that cross?
Cross, my lord. But they have not gaps in the chain of custody. I would
Oh,
find that
is it required?
This is something which is your prosecution witness has demolished your own case. Whether the seizure now is doubtful.
Doubtful.
The color of the material, three
Doubtful.
colors. One says yellow, one says gray, and he is very, very categorical on that.
Yellow.
Your seizure list, H.C. Das, who is the man who had made the inquiry, he's very, very categorical.
Lordship. Yes. But my lord, your lordship can also see regarding the color, my lord. One is saying by yellowish and brownish, my lord.
No, only yellowish.
No, my lord. In the
The
FSL
FSL is brown
down. So my
and
lord,
your report
yes.
is gray. And
Okay.
three colors are not the same.
yes, right. That is PW1, my lord.
PW2.
Two.
One in one smile it is saying as yellow, my lord.
No. One says only powder.
Powder.
Powder-like substance.
Powder like.
And your additional SP was not examined. Or was he examined? No,
No, my
No, he was not examined.
he was not examined.
W2, my lord.
Yellowish powder. And the
Two say
PW is, my lord. It is
in the seizure report,
packet contains yellow. Down, my lord. That yellowish, my lord. That is what.
and your presence of your additional SP on 6-9 is doubtful now because of that evidence. You have not demolished that.
Moreover, sample cannot be sent directly to the SP without putting the court, my lord. So it must be signature of the CGM.
Where is that provision?
There is a, NDPS there is provision.
Yeah. First, my lord, after my lord sampling,
Seizure.
They have to
That
produce
sample-
before the court.
that sample has to be
Court is to satisfied
as per section
and give a certificate.
50?
50A. And there
Will give a certificate that everything is okay. Is missing? Not in the record. I have seen the peruse the record also.
$52 is not there. Not 52.
act, my lord.
Act.
52.
52 section. Oh, sorry.
Section, man. Paragraph, section, subsection.
Every person arrested and the article
C.
seized under warrant issued under subsection 1 of 14 shall be
Not done. Moreover, the public has seized this contraventions, alleged contraventions, public, and handed over to the police.
that is the evidence in 102 that towards the end one person says so. But the police evidence is that no, it was seized by me from his person, and you have not crossed him to that. So we'll not go into that.
And so almost 3 months I was inside the jail. Sentence is 6 months.
But you are involved in this. Can't help it, technicality.
We had to jump on the technicality, my lord. Otherwise, in a NDPS case, it is very tough, my lord. Get out.
Heard Mr. S.C. Biswas, Learned Counsel for the petitioner. Also heard Mr. M.P. Goswami, Learned Counsel, Learned Additional Public Prosecutor, State Respondents. Hearing concluded, raised by Albert, Thursday, for
Diplomat.
delivery of orders. If anything is there, tell me.
That must only, my lord, because regarding brownish, my lord, from FS.
See, these are very technical things.
Yes,
If it gives a rise to a doubt, how can we? You send a, what do you call that, yellow gray thing, it becomes brown. It can become brown. But there should be an explanation. By this material, after so and so time, it becomes brown. Seizure part is not good. And seizure is again doubtful. Okay. Yes, Mr. Chaudhary, what are you waiting for? 33. That is for delivery of orders. We can only pass anything further to say in this. We'll dispose it up in the similar lines. That much only. Justice Burwa's order you have placed, we'll dispose it upon that lines only. But after completing the old matters. You need not wait for that.
Again, special development.
Mr. Ayuddin. Okay.
Cylinder meter, Lordship.
Huh?
PG cylinder meter.
What can we do here?
PW1, Lordship, here's
Can
that
we
it
do?
was seized from the footpath. And neither he says that it was used for any other.
No, there is evidence that it was used for your.
PW1, that he is the
Right,
only
but
independent.
PW3 says that it was used for your to melt the gold
Even,
ornaments.
it was not proved that I am the owner of, or proprietor of that particular. Secondly, these two, W2 and 3, they are the officials of civil supply. Only witness, independent witness is W1, and he says that it was seized from the. He signed the seizure list. W1, one witness.
And this is concurrent finding.
And
Me across to that effect.
Lordship, PW1s.
Yes.
Let me read the entire examination, Lordship. মই এই গছৰ গছৰীয়া মই গছৰ গছৰীয়া মুকুল শৰ্মাক চিনি পাওঁ, আছামী ৰাজা আলীক চিনি পাওঁ, আজিৰ পৰা বজাৰলৈ বুলি ওলাই আহোঁ, আহি থাকোঁতে ৰাস্তাত ফুটপাথত গছৰীয়া মুকুল শৰ্মাক লগ পাওঁ আৰু তেওঁ মোক কয় যে এই এটা চহী দিব লাগে আৰু আছামী দোকানৰ পৰা গেছ চিলিণ্ডাৰ মোৰ চিলিণ্ডাৰটো সেই সময়ত মই পাওঁ গেছ চিলিণ্ডাৰ জব্দ কৰে মই মুকুল শৰ্মা মই চিনি পাওঁ ঘটনাৰ সময়ত মই বাটেদি গৈ থাকোঁতে মুকুল শৰ্মাই মাতি পেলাই ক'লে যে চিলিণ্ডাৰটো আছামীৰ দোকানত পাইছে by Mukul Sharma that it
Fine, go ahead.
মোক সাক্ষী আৰু মোক সাক্ষী হওঁ আৰু মই চহী কৰোঁ মই চিলিণ্ডাৰটো ফুটপাথত দেখা পাইছোঁ ফুটপাথত আছামীৰ দোকান that
No explanation in your 313. Then what is the further witness? The Caesar, the authority that is, he was PW2.
is the complaint.
Complainant. What? What is the cross, if you can see? My cylinder seize kora dukan to নাম ৰাজা আলী সত্য নহয় যে চিজাৰ লিষ্টত চহী আমাৰ একে ডিপাৰ্টমেণ্টৰ মানুহ পৰা চিলিণ্ডাৰ domestic cylinder.
It should be that.
Now, if you come to 3, Ananda Kishore Kanu.
Sub-Inspector, Food and
Section
salary
48.
শপথ কেছ হৈ আছে
That's the normal one. Cross.
এই দোকানৰ মুকুল
Right.
এপিডেভিট ওৱান was
Messrs. Ujjwal Jyoti Gas Agency. আহিছিল মই দিন
one cylinder was seized, but Jima was two cylinder.
on evidence. PW3, that he says also says that this was used for melting. What is the nature of the punishment in the for this offense?
In the by the trial court,
Minimum 3 months.
2 months,
and
3 months.
3 months and 3,000. Earlier trial court 5 months, 6 months, 5,000.
This is under section 7.
7 and 6 better. 8 no.
Seven
7 1 2.
1A2, Roman 2.
A.
Any other order.
Any case of any other order, imprisonment for term which shall not less than 3 years, but
Once.
may extend to 7 years, and
As a-
shall also be liable to fine.
Provided that court may, for any adequate special of imprisonment for
You have not been detained. Will the Probation of Offenders Act apply here?
Only on that purpose.
Dispose it off in that light. So considering the long lapse and he not being involved in a similar offense, will go oneself, disposed of. But you'll get these orders next week only, huh?
lots of.
You're on bail,
Yes, I will.
disposed of. File kita dispose di kita bisa move. None appears for the petitioner on call. This is a revision petition. We'll dismiss it on, we'll dispose it upon merits. You make your submission.
5 of them, my lord,
Concurrent findings?
in my lord. One conviction, my lord, and final rupees 1800.
This is under stay. This is stayed by this court.
Her deposition
498A, her deposition shows that she was tortured,
was mentally as well as physically.
physically tortured. He used to have a party, wine party, get ladies to his house, for which she was chased out. 25,000 dowry demand.
allowed to, my lord.
When was the order passed by this court, interim order? No, before that also there is evidence.
That is also evidence, my lord.
That was a news item also.
Right.
So
1, 2, and 4, my lord.
okay, দুটা বজাত দিব দুটাই বাকি যিখিনি আছে কৰি কেনে এইকেইটা অৰ্ডাৰ দি দিম 2 o'clock will proceed. Yes. Mr. Singh, B.S. Singh is that injury is corroborated by the medical evidence. What to do? This is criminal revision. Okay. Oh my God, it came last when my Lord Justice Chaudhary was here. 2013. Yes, what do you have to say?
All the W2,
Everybody and the PW, the medical officer
medical
also.
officer also. There are 3 injury there, and
Dutta was up. Second half, ordered him. We are dismissing. Yes, what do you have to say here? Okay, you go through it. We'll take it up in the second half. Here, the penalty is 324. Illegal restraint not proved. 324. Uh, 2 years and 2000. After such a long time, what to do? We'll limit it to the conviction will maintain. Fine. Or 324 or fine or with both. So we'll limit it to fine. Okay. So serially material by leftover type material. Yes. Yes. What is your submissions? I will hear you. But none is there in the government. Oh. Second half material. None is there. Get somebody. Video. If I let it video. Yes, Mr. Signar. Mr. Signar, there is none. But Mr. A.R. Signar, Lana Counsel for the petitioner. There is none representing the respondents. Post for the ends of justice, registry to list this matter again after 2 weeks on a date to be fixed by. The matter will not be considered as a parted and or tied up matter with this court. Because maybe they are not here because I'm taking a criminal bench. Oh yeah, you go through. That revision petitions you go through. If something is there, tell me. What is your name? You are there in the case? J. Abbas. Heard Mr. J. Abbas, Learned Counsel for the petitioner. Baki non appears kori, agor nisna. Kore diba. After 2 weeks, because they are not here, maybe because this bench is not taking up that matters. Interim order passed earlier to continue till the next date. Not treated as a part hard play. None appears for the petitioner on call. The registry to list this matter again after 2 weeks on a date to be. Next to same. 56 to same.
56.
Same. Beleg ke maidi ba. No, 57 to mato.
57.
Here. The Gayan wanted to take as a second affirmative. So we'll have it in the second half. Because maybe. Mr. Muzumdar, you need not wait for that. We'll pass the orders. Provided we complete with the old matters, then we'll go and pass the orders. Possible today itself.
Yes.
You need not wait. You get it uploaded in a day or two.
Listing in matter.
No, I'm not sure. If I can finish off the list, the old matters, then I'll pass the orders today. First 2 matters.
I'm here because right.
We'll see in the second half. None appears for the petitioner on call. Parties on call. Who's up? For the ends of justice, registry to list this matter again after 2 weeks on a day. But this matter will not be treated as so and so. That was it. And you'll hook up. To me, it took complete koilo. There will be a day or 2 delay in getting the uploading the orders. So kindly bear with that. We are trying. The people they've.
Yes,
Oh, there was 56, 55 and 56. Do you agree to the transfer?
Opposition.
Okay. We'll see. There was some flooding, we were told. So they are not here. So let's see what happens. We gave 2 weeks. Because there is already a stay order operating. What is your name? Okay, we said none appears fine. 2 o'clock, we'll say. Introduction item number 37. Property level.
48, same page. Black mark, my lord, lordship. Repeat, my lord. Provided that the where the minimum daily rates of the wages notified under the act has been worked out, but driving minimum 26. or where the actual daily out by dividing monthly rate of wages by the such actual daily not less than notified daily rate wage. No wages, Lordship kindly note, my lord. Wages for the rest day schedule and in employee works on the rest day and has been given substituted rest day, he shall for the rest day on who worked an amount equal to the wages per time rate. Any dispute arises whether the daily wages has been worked out or said the chief labor commissioner so and so made an
What are you trying to project, Mr.?
my projection is that, my lord, in response to the page 298 filed by the railway authority, my lord, lordship kindly take out the page 98 state where affidavit filed by the railway. And I have annexed, my lord, just now the complete copy of the annex 98, my lord. Key part, my lord, lordship kindly see some rates of wages include the of the
298.
98 page, my lord.
298 is something else. This is minimum wages. D.
Yes, my lord.
Minimum wages include the wages for the weekly day of rest. The law is that he will be paid the wage of the preceding day, right? That's all.
Yes. Divided by the 26 day.
How can you, once you divide it by 26?
No, divided
Mr.
by 30.
Mr. Yeah, let us go by your this
My
thing.
lord.
We are reiterating this. Say you have a monthly wage. How do you get the daily wage? 26. In terms of this provision, 26. Finished. That takes care of the 4 days. 4 days of rest, that takes care. So now, if you have to convert the daily wage to monthly wage, you will have to multiply it by 26. Now, if you divide it again by 30, you are getting a lower amount.
Lordship, I have given a calculation, that argument copy, my lordship will see.
Where? Where have you given? Have you given a copy to Mr. Decca?
Yes.
Okay.
Page, Nikki. Second page, my lord. That is for insurance, my lord. Other day I have given bill, my lord. Argument on the other day, ulai dia. It crosses 21, then
This is what the railways are trying to project.
yeah, that is exactly we are following.
That's true, but that is not the way we have understood. That's why we wanted your assistance.
Apart from
So, if you divide it by 20, if you multiply it by 26, and then you divide it by 30,
30, that
you're
is the
getting
formula, my lord.
it's not the formula. It cannot be the formula.
That is, I have
You
given
can't have a rate below the minimum wages.
Monthly wages is 3,000.
Divided by
They
26.
are arriving at the daily wage by dividing 3,000 by 30. 1,000. Now they are making the PF calculations by taking it to be 1,000. Now to arrive at the monthly wages again, they are multiplying it by 26.
They cannot.
There
They
is
cannot.
two, my lord.
If
One
it
is
is divided
Because
by
why
30,
I am
it has to
saying,
be divided by 30.
why I am saying so, if you multiply it by 26 and divide it by 30, you get a amount which is lesser than
But, my lord,
the minimum
has said,
wages.
my lord.
How can you go below the minimum wages?
My lord.
You are also, see, the wage is calculated so that the contribution of 12.5 can be taken out, right? Now, if you calculate that at a lower rate, you will be paying as an employer a lower rate of PF. The drawal from the petitioner will be lower,
Not
the
petitioner, but the
workman will be lower, which will be in violation of the beneficial provision that is given.
I'll just come to clear, my lord. Lordship, kindly have a look. Last occasion, I have relied on judgment of the apex court, my lord. Para 7, my lord. It has been indicated that your lordship kindly turn to page 15 of my earlier argument, my lord. That has been decided, my lord, in this particular case, my lord. Para 7, while calculating the per day wages, the monthly wages shall be divided by 30 days.
26.
Or 26, sorry, my lord. But for deduction, if any, shall be calculated monthly wages divided by 30.
wages, particular minimum wages not.
Yes, yes, that notification para 17, my lord. Now, lordship,
25.
kindly page 25. In our conclusion, in respect of the some part of the notification will not affect the notification as such. The part of the notification other than that which are dealt with by this judgment shall continue to be in force. Cannot go beyond that, my lord.
That, my lord.
We
SCC
make it clear, the employee shall not be entitled to recover any amounts paid under the notification. We are not going to recover, my lord. That part is not our recovered matter. Now, my lord, lordship's question, page 20, page 15, followed by page 25 of the judgment, which has been held. There, my lord, I have annexed earlier last month's salary also.
Just a moment, just a moment.
Let me move copy to
Okay.
now,
Okay,
lordship.
we understood this. So, to get that amount for
More
deduction,
clear, my lord.
for deduction, 655 into 30 divided by 30. Finished. For deduction, it will be by 30.
30.
So then, if it is for deduction, how can you arrive at a monthly wage by 26? This is, while calculating the per day wages, the monthly wages shall be divided by, this is in tune with the provisions of the Minimum Wages Act.
My lord.
But for deduction, if any, it shall be calculated that the monthly wages divided by 30. So 26 is for payment of wages.
If any recovery or
But for
anything,
deduction,
yes,
but for deduction,
anything else.
30. It does not say for deduction, you will all multiply by 26, then divide by 30.
Or whatever the rule says, my lord. Just now I read out, my
Okay,
lord.
fine, we'll examine. Now we'll have to examine.
Yes, yes. Now, lordship, apart from that, my lord,
that is
another thing I like to
reported in
apprise, my lord.
2019, 15 SCC 774. My lord, I think same judgment is reported, my lord. 2019, 15 SCC 9774.
We can also have these things. 2019,
15 SCC 774.
the only problem here is the net connectivity. In
SCC 774.
দেখা কি হলে net ইমান কিয়?
That apart, lordship will see.
What is the citation?
2019 SCC 774.
What does it say?
Same judgment. my lord.
No, it's not opening.
Here, my lord, the issue was
You
entirely
all have better connectivity. Ah, it has come. Hindustan Sanitary Ware.
yes, same judgment which my learned friend is relying.
Then what does it say? Para?
Kindly come to 19, my lord. Here the issue was entirely different, my lord. Wages part was divided into certain components. There in 19.2, the upshot of the above discussion is
Creation of segregation.
allowances in the, there it says about deductions from
I'll go through it.
examine this.
I'll go through it.
Another thing, my lord, I like to apprise my lord for again further clarity, my lord. Lordship kindly turn to my written argument page, serial number, page number 12.
Not on record, not on affidavit, my lord. Wait.
The argument, my lord, I
You are
was not
trying to
allowed.
understand something, mister.
Was not. And lordship will see serial number 1 and 2. That calculation part I have given, my lord. Page 10. One person has worked 26 and another person worked for 21. One person is 21.
Yeah, once you appoint somebody to work as a workman for this work, you can engage him for 26 days only because he'll have to be given a weekly rest.
Yes.
That is an understood thing. But while you quote, you are not quoting for a particular worker. You are quoting for the period wherein that man will also be replaced by somebody else.
That I have given, my lord, pay slip.
Okay.
Pay statement, lordship kindly
Lekha.
plus.
Fine. And this is the end of the matter. Huh?
My
No
lord,
further
my
arguments.
lord.
Heard Mr.
I have given, my lord, notification in.
Okay, we'll
complete
go through it. Heard Mr. N. Deka, Learned Counsel for the petition. Also heard Mr. J.I. Borbia, Learned Counsel, appearing for the respondent number 4. So, although the case was listed for delivery of orders today, Mr. Borbia had requested for making further submissions, which was permitted. So, accordingly, Mr. Borbuya's submissions were, Mr. Borbuya had filed an additional written argument, which is taken forward, and a copy thereof is also handed to Mr. N. Deka. So, this court has further heard the Learned Counsel for hearing concluded. Full stop. Registered to list this matter again on Tuesday, at 10:30. It file mulla 10:30. Now, please don't come up with anything.
Oh, my lord, I'll not come anything. Now, my lord, I'll just like to reply. In that judgment, my lord, they challenge some particular that has been.
Now, let me understand.
Yes, up to your lordship.
Let me understand.
Lordship will examine. my
Either of you will have to
Yes,
go
yes.
to the next forum.
Lordship.
And we will not go into the nitty-gritties. We'll only clear this part of the matter.
My lord.
26 or 30.
My lord, that
Into 26 by 30 or
yes.
into 26 by 26 or 30 by 30. That's all.
My lord, my reference.
This court will not understand more than that.
That much my prayer, my lord.
That is the challenge, my lord.
Hey, fellow, ito tak ko radio. Fellow, no, you can take the book back. Okay, give it back. You write down the page number in your written argument somewhere. Yes, Mr. Gugoi.
That torture was also proved, lordship.
Anything more? Also, heard Mr. N.J. Gugoi, Learned Counsel, and Learned Amicus Curie, appearing for the petitioner, and Ms. S. Kanungo, Learned Counsel, Amicus Curie, appearing for the opposite party. Also, the present criminal revision petition has been instituted by the petitioner, assailing the judgment and order dated 22/1/2013, passed by the Learned Principal Judge, Family Code Roman 2, Kamrup, Guwahati, granting a maintenance of rupees 4,000 to the petitioner herein and her 2 minor children, with effect from the date of the order. Also, the facts in brief requisite for adjudication of the present for the issue arising in the present proceeding is noticed as under. Also, the respondent herein had instituted instituted proceedings before the Family Court Guwahati, which was registered as FC bracketed CRL bracket over 548/2009. So, in the said proceeding, it was projected that the respondent herein had projected therein that the marriage between the petitioner and the respondent herein was solemnized on 24th Aghon in the year 2005, according to Hindu rites and customs. Also, during the conjugal life of the parties herein, 2 male children were born to them. Also, it was projected therein that after lapse of some period of time from the date of solemnization of the marriage, the petitioner herein started demanding material objects from the family, from the petitioner herein, which she was to procure from her family members. Also, as the respondent herein failed to fulfill the demand for dowry, the opposite party, it is alleged, used to torture her. Also, such torture was also projected to have been committed upon the respondent herein during the time when she was pregnant. Also, it is alleged that it was further projected in the said proceeding that the petitioner, that in addition to the petitioner herein, his parents and his sister-in-law also is to torture the respondent and had also not provided to her food on many days. Also, it is projected that on account of the said torture, which was due to non-fulfillment of the demand of dowry, the petitioner, being unable to bear the same, had left for her parental home and had informed about the torture committed upon her by her in-laws to her family members. Also, it is projected that there was steps taken by the family members of the respondent herein to reconcile the petitioner along with the respondent. However, on account of the defiance shown by the petitioner herein, such a reconciliation had not occasioned. Also, the respondent in the said proceeding had also alleged that the said torture as committed upon her by the petitioner was on account of the objection raised by her with regard to the relationship maintained by the petitioner with his sister-in-law, and that she had seen both of them in compromising position frequently. Also, the petitioner had claimed for maintenance from the respondent had claimed for maintenance from the petitioner, and in this connection, she had projected that the petitioner was a businessman running a clothes shop and had a monthly income of 18,000 bracketed 18,000 besides having landed property. Also, accordingly, the petitioner had claimed rupees 6,000 as maintenance for herself and for her minor children. Subpara. The opposite party herein had contested the same said proceedings by way of filing his written statement, and therein had projected that he had no income to maintain the petitioner and even to maintain himself. The ownership of the cloth shop, as alleged by the respondent herein was denied by the petitioner. Also, he further alleged that the petitioner herein had illicit relationship, or a respondent herein had illicit relationship with one local youth before the marriage, and the same continued after the marriage also. Also, he projected that it is on account of the petitioner herein further projected that it is on account of the said illicit relationship maintained by the respondent that she had left his house also. Also, the learned family court, basing on the materials coming on record, had framed issues in the matter for determination, also, which would be considered at a later stage in this order. Also, on consideration of the evidences coming on record of the parties to the proceeding, the learned family court provided the judgment and order dated 22/1/2023, 13, directed the petitioner here, to pay an amount of rupees 2,000 per month to the petitioner and an amount of rupees 1,000 per month to each child, totaling rupees 4,000 from the date of the order as maintenance. Also, being aggrieved, the petitioner has instituted the present revision petition. Mr. Gogoi, learned counsel, learned amicus curiae, appearing for the petitioner, by referring to the deposition of the parties before the family court, has submitted that the same would bring to the forefront the fact that the petitioner had willfully abandoned her matrimonial home and had stayed with her parents. Also, he submits that the torture as alleged by the petitioner, by the respondent to have been committed upon her by the petitioner, has not been established by the evidences brought on record by the respondent hearing before the family court. He submits that he further submits that the evidences adduced in the matter on his behalf would go to reveal that he is only an employee working in a cloth shop, which is owned by his brother, and had an income of rupees 1,500 to 2,000, and accordingly it is not feasible for him to meet the expenditure of his wife and his children, more so when they are living separately without any reasonable cause. Also, accordingly, he submits that the judgment and order dated 22/1/2013 passed by the family court, having been so passed without a proper appreciation of the evidences coming on record, would call for an interference from this. Anything more? Per contra, Ms. S. Kanungo, learned amicus curiae, appearing for the respondents, by referring to the deposition of the respondent hearing before the family court, has submitted that the same would bring to the forefront the torture committed upon the respondent by the petitioner herein. She submits that the petitioner was forced only on account of the torture committed upon her by the petitioner and his family members, that she had to proceed to her parental home, fearing that she would be killed and also harm would be caused to her children. She further submits that the evidences coming on record would go to reveal that the petitioner herein maintained an illicit relationship with his sister-in-law. Also, she submits that the deposition as made by the petitioner in the proceedings, by the petitioner, as well as the witnesses adduced by her in the proceeding, as well as the other witnesses adduced by her in the proceeding were not dislodged by the cross-examination by their cross-examination done by the petitioner herein. Accordingly, she submits that the petitioner, being a man with means, would be the amount of maintenance as determined by the learned family court, while the impugned judgment would not mandate an interference from this court. With regard to the allegation leveled by the petitioner against the respondent herein of she having maintained illicit relationship with other youths, she submits that the same was not established before the learned family court, and no name of such persons were given, and if so given, the same was vague without any material particulars. Anything more? Also, Ms. Kanungo has further submitted that the materials brought on record would go to reveal that the petitioner herein had not disputed the paternity, but disputed the solemnization of his marriage with the respondent herein, as well as the paternity of the children born in pursuance to such marriage to them. Also, in view of the above, she submits, in the above premises, she submits that the amount as determined by the learned family court being at a lower stage, the same would not mandate any interference from this court. Also, I've heard the learned counsel for the parties and also peruse the materials available on record. There is some interim direction here. Are you being, you don't know, how can you know? Full stop. Anything more? This much will do. Well, any idea? Backing my forward to use. Done. Dismissed.
Apply this.
Come on. Yes, Mr. Mandal.
I have gone through the uses, particularly PWP. That does not make any offense, as I have seen, because there is a merely allegation. That too, there is a huge contradiction.
1, 2, and 3, the contradiction is with regard to meeting of the accused appellant. Father has not in the affidavit said that he had also talked with the appellant when he had come home. But in his evidence, he brings that on record. But at that point of time, if you are on that point, at that point of time, he was in the hospital. So that delusion is there. So he may have missed out something. But subsequently, after say discussion with PW2, Regina, who had not taken the food at that night time because she was having a stomachache, he might have learned about this. He has stated this. What is the error in that?
But Lordship,
it is not an exaggeration as sought to be projected.
Of the case, but the source of the case, that was not verified by the medical report or FSL report. What is the offense? If I go to the extent that there is no medical report, there is no FSL report, which suggests that there is a...
Where is your cross to that effect before the trial court? Where is your cross? Where is your material? You can't just come and build up a case here. You'll have to build up a case from the trial court itself.
Now, that apart from I have been instructed today itself over telephone. This gentleman, the appellant, he is missing since last 9 years. And the family members also do not know where he is about.
Okay.
That has to be verified by us also.
That is none of our business here.
Now, if the decision is against the appellant, or
the police will find out, Mr. Borua will find it out. And this is mind you,
2013.
5 years, 10,000, 328. Anything more? Anything more? Something more? You have not understood what I was indicating in the morning. Hey, record kini, trial kini tak. Something more is required. Periphery nahi hoga. You will have to come in. You're in the periphery.
Yes, my lord.
No, not that case.
We need some time
It's
to.
not 2 years, Mr. Mondol, I have come this side. These will not work with me. After maybe 1 more year, it may work.
For 3 days, because my lord, without having file, my lord, we cannot, my lord, assist the code also properly, my lord. File is with my learned friends, my lord, Mr. Muria.
Yes. Okay. Now, what are the circumstances according to you?
Day, my lord. When my lord.
Now you to show me something from the record that somebody had seen this matter being put in the.
W2, my lord.
W2 is Regina. Regina. Huh?
Entire, my lord.
Just that part.
Password. আমিয়ে আর কেৰাহী ঢাকোন আঁতৰাই আৰু আঞ্জা তাৰ হাতৰ মুঠিৰ পৰা
Fine.
মই গম নাপাওঁ আছামী ঘৰৰ পৰা গুচি যায়
Gusi jai.
তেওঁ ভাত খোৱা নাই আমি ভাত নোখোৱা খবৰটো তাৰপিছত ঘৰৰ বাহিৰে বাকীবিলাকে ভাত খাই শুৱে
Why she? That is the ways where it is doubtful. They have not crossed her nicely. She is the only one who has not taken something fitting.
She has not taken, she has also.
That she has explained that she was having a stomachache. Now, she had not reported this pouring to anybody. Why? One. So that exaggeration I'm trying to put. Because he went, mother did not see. Mother was there. Mother did not see. Mother just came out. Be that as in, he went to light his bidi. But this whole charge sheet that you have filed, if you go through the charge, it is a projection that this was done to commit that offense. Now you come to 328. Come to 328. Just correct me if I'm wrong. Whoever administers so and so with the intent to cause hurt to such person, right? Or with the intent to commit or to facilitate the commission of an offense, or knowing it to be likely that he will thereby cause hurt, shall be punished with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. Now, you tell me, in this case, what is that allegation? Not to cause harm, to cause
Some, my lord,
and then commit a robbery.
Yes, my lord.
Then commit a robbery.
Yes, robbery, my lord.
Right. But now you come to the findings of the learned trial court. Now you see what he is saying. As regards the other accused person, there is no worthy evidence. There is no allegation that the so-and-so with the had committed. Now, there is, see, though there is allegation that the principal so-and-so, 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 the prosecution has failed to establish the guilt of the accused person for alleged commission of offense under 457 and 380. Lurking house purpose and the stealing, not established. So 328, that part, you show me how it is established.
Purpose, my lordship, may kindly.
PW2, you read, you tell me what is required.
আছিলে যদিও সাৰ পাওঁ আমি তাৰ সময়ত ঘৰৰ
মানুহ আহে. She has not seen any accused.
fine, man. That is why I'm
How can I go beyond that? If the learner try, you have not filed an appeal here.
I have not filed an appeal, but
I'll consider.
the materials.
See, show me some evidence to show that the accused was also involved in commission of the offense. Only evidence that is there on the record is this extrajudicial confession.
That trial court
That
has
trial court has
has
negated.
denied,
Where is
my
the
lord.
material?
That, my lord, since I
That is gone.
stand up, my lord. So,
So,
out of fear, my lord,
through
he must have-
5780. Now you will have to highlight, an explanation has to be there, or something has to be there, that this was done to cause harm to them, which is not the case of the prosecution.
My humble submission, my lord. First, my lord, they become unconscious. They were unconscious till the next day evening, my lord.
I know,
They were hospitalized.
I
my
know.
lord.
But
These
where
are
is
the-
that, because I'll have to consider 328 in its full. Where is that effect?
I think, my lord,
Because your thing is, this was done only to commit an offense of robbery. If you can satisfy me on that point, we will allow some time to Mr. Mondal to make his submissions. Otherwise, gone. See the charge sheet also, the projection. It is with regard to commission of that offense. Mr. Borwa, it's a serious matter. We will not rush you down. We'll take up this matter again day after. You formulate. And Mr. Mondal day after. Just take me out of that issue. We will find out where this man is missing for the last 9 years through you.
I also not found, my lord. Permanent, my lord.
Because he has not even stated that thing. Cost is very bad, but can't help it. Okay. Heard the Learned Counsel for the parties at length. Mr. Mondal, M.U. Mondal, Learned Counsel for the appellant, submits that he be granted time till Thursday, to make his further submissions in the matter. Accordingly, registry to list this matter again on Thursday, date to deliver, as a top of the list item. In the top of the list column. Mr. Mondal, one evidence is very badly against you. The second time you came and asked whether you have had food or not. That is against you. Why? That no. You have not disclosed that in the cross.
That has been negated by the other PWs.
No. You, that is there. We are trying to get something out from Mr. Borua. If we get it, you are in trouble. Yes, Mr. Uddin.
For a conviction under 41
Hmm.
forest regulation,
Hmm.
6 months and fine of ₹3,000.
Hmm. Hey, to Dioxin, you have that Act, Assam Forest Regulations. What is the penalty, pension? What is the punishment prescribed there?
3 years.
Asan niya mo to, 9 years. Yes, Mr. What do you have to say?
The state government may by a rule under the last foregoing section attached to the of any rule under that section, any punishment not exceeding imprisonment for a term, which may extend it to 3 years, or fine, which may extend it to 5,000 rupees, or both.
Or
Either fine, either conviction or fine,
Or both.
or both.
yes, Mr. Uddin, take some. You have done many cases today. Take some rest. We'll have.
My lord,
Mr.
one thing, my lord, that 4 witnesses examined, my lord. All are, my lord, from the forest department, my lord. And my lord, I have a, my lord, husband, my lord, I'll furnish, my lord. That, my lord, that the witnesses, all are, my lord, government. That is not, my lord, fatal, my lord.
It's not fatal.
There is one judgment regarding that, my
That,
lord.
because at that point of time, you can't expect somebody else
Yes,
also.
man. Yes, man.
So they were proceeding in this cycle along
Yes.
with this
Yes.
Gamari cut and
Yes.
2 types,
Yes, my lord.
which is also said to be used, which can be used because they are going in a cycle, so they are not going with logs. It's basically firewood, right? So this offense is of this offense is of
10 years.
2002, 23 years back,
Yes.
right? They have suffered enough. I'll not, don't think that they are with Mr. Uddin, so they are suffering. I'm not meaning that in any manner. I'm not meaning that in any manner. So, where is that provision?
41.
Where is the rule? There is a rule.
Rule is there. 2005.
Because why a rule was not framed here? Can you get Mr. D. Gugoi or Mr. D. Gugoi or Mr. A. I. Bhattakur?
My lord, I am also appearing for the
Forest Department. Okay.
my lord, rule followed by the regulation, my lord.
It's there. Then no need, no need to. If you are there, then no need. Rules, Assam sale of forest produce. That is Assam sale of forest produce scope rules. Take this book. Because here the penalty has been issued, the punishment has been issued under section 41.
6.
Okay. Anything? Because it says that a rule has to be framed. Because the the punishment here is also under section 41. Can it be done under section 41?
My submission is otherwise. My one provides for any breach or made under regulation or any rule thereunder.
But here, where is that rule?
The forest produce has been defined in section 3. There are 6, 7 ideal. For a moment, kindly take it up.
That Assam Gazette.
Show me. Just wanted to know.
Forest produce has been defined. Section 3, subsection 4.
No, that is substitution of rule section 41. That notification. Mr. Uddin, you are referring to 3?
Section 3, subsection 4. Definition of forest produce.
Forest produce.
Timber, karkal, kochok, techu, wood oil, resin, natural, varnish, bark, lake.
Got it. Got it. What do you want to submit?
What is seized from the present petitioner is firewood. Not
No, there is an evidence to that effect. That this was cut and this was not logs, but it was cut wood.
Log.
Not logs, cut wood. You come to PW3. Were split, sources were split as well as cut. So it is a forest produce, but you had not taken it as a log, but it was split as well as cut.
He has not said these are, he says they were carrying timber on bicycle. W3, page 23 of my petition in the trial court judgment was quoted. PW3 Shuren Bora deposed that on such and such, he along with so and so were patrolling. When at Kiring Azabari area, they apprehended accused person carrying timber on bicycle. 3 deposed that as the accused person could not show any document, the timber was seized and the accused person along with the seized timber were brought to Hujai. Cutting, there is no evidence that they have cut it from and the seizure was made 3 kilometers away from Malad forest area. 9%, 2 were declared absconder. Case against them was filed. 7 convicted, only 2 for your lordship. The remaining 5 not before your lordship.
What happened to them?
9 were apprehended.
What happened to them?
9 apprehended.
Why? What happened to them? They have undergone.
Probably because it is, we are 2013 judgment, we are after 12 years.
How long were you under detention?
We are arrested on 12/2/2002 and 24/3/2002. I have seen in the record that they were allowed to go on previous way.
And before the thing, they were not.
Between, I have not found any order.
No, before, prior to the trial, were you at the initial stage, once you were arrested, were you behind bars?
Incident was on 12/2/2002.
Or 24/3, you have been allowed to go on bail. And there is an interim order here also. Yes, Mr. Sama. Mr. Bodhakur, one clarification. If you read 41,
Wait, may by.
It says state government may by a rule under the last foregoing section, that is 40. It came in 1950, okay. Attached to the breach of any rule under that section, any punishment not exceeding imprisonment for a term which may extend to 3 years or fine, which may extend to 5,000 rupees or both. So a rule is required to be made. Where is that rule?
Rule.
Some provisions, my lord.
No, I'm on 41. This prosecution is under 41. Because of section 40. There is a rule to be made. Because if we find that there is no rule, how can this provision be applied? If so, whether it is applicable. So, we got your point. We can
The
give you.
evidence is that Hori loi jai.
Hori.
Hori
I've seen it.
Hori loi jai.
But only my thing is whether by invoking 41 per se this penalty can be done, or there has to be a rule under 40.
40 says there are so many heads. So many rule has to be framed.
No, but what that is up to the government.
Rules here in this book.
No rules. That specific rule is not there.
That is
Route through which the timber can move. So let us have that. You are having an interim order.
Yes.
Huh? When? Heard Mr. Ayuddin, learned counsel for the petitioner. Also heard Mr. E. Sharma, learned additional public prosecutor, and Mr. B.V. Sharma. Also, during the course of the hearing, an issue has arisen as to whether the provisions of section 41 per se would have been applied for convicting the petitioners herein. Also, a perusal of section 41 of the Assam Forest Regulation 1891 reveals that the state government may, by a rule framed under section 40 of the said regulation, attached to breach of any rule under that section, any punishment not exceeding imprisonment for a term which may extend to 3 years or fine, which may extend to 5,000 rupees or so. It is not clear as to whether any rule has been so framed by the state government under section 40 of the said regulations of 1891. Accordingly, this court requested Mr. I. Thakur, learned standing counsel forest, to apprise this court about the same. So, Mr. Thakur submits that he would complete his instructions in the matter and apprise this court on the next date of list. So, accordingly, raised it to list this matter again on Monday for further hearing. We'll see.
Right.
If that is not there, the whole prosecution is vitiated. I may be wrong also, but if there is something that it can be done under 41 without a rule also, kindly apprise this court on that also. Otherwise, if that be so, Hori, poor villagers, now after 23 years, who is going to do that? We'll have to do it. None appears for the petitioner. Asil to Kumba. Kumba asil to Ratipa. What are going to Commodities Act. Commodities Act. Yes, Mr. Goswami. Item, that gas cylinder. Mr. Chutia appeared. Why did we keep it? What? Forgot. Alam also appeared. Can you just follow up Pishot Matidi? Yes. Probation of Offenders Act would apply here. Apply. That only. Just get them. Yep. Concurrent findings. Somebody had appeared in the morning, I suppose. Somebody had appeared. You had appeared. Nobody had appeared for the petition, I suppose. Nobody had appeared. None appears for the petition on call. R.J. Burwa, learned additional public prosecutor, appeared for the state respondents. None has appeared for the respondent number 2. The present criminal revision petition has been instituted by the petitioner here, assailing the (498) A is There
are 2 exceptions under 490.
Assailing the judgment and order date 19/9/2011 passed by the Subdivisional Judicial. You find it out, bracketed S. Bongaigaon in GR case number 346/2000, convicting the petitioner herein under section 498A IPC and sentencing him to undergo simple imprisonment and to pay a fine of rupees 1,800. In default, to undergo simple imprisonment for 1 month for the offense under section 498A IPC. The petitioner has also assailed the judgment dated 19/6/20 passed by the learned additional session judge bracketed FTC, Bongaigaon in CA number 31 bracketed 4/11, upholding the conviction of the petitioner herein by the learned trial court. Also, the facts in brief requisite for adjudication of proceeding is not as under. Also, the respondent number 2 herein had lodged an FIR on 22/9/2025 before the Bongaigaon officer in charge Bongaigaon police station, inter alia alleging therein that inter alia projecting therein that she was the legally married wife of the petitioner here, and that their marriage was solemnized on 25/2/2000. So it was also projected that their marriage was also registered under the Special Marriage Act 1954 before the sub-registrar Bongaigaon on 18/12/2024. 2004. Also, in the FIR, it was further alleged, it was alleged that the petitioner herein after the marriage after the marriage was living at her matrimonial home, and the petitioner started to torture the respondent number 2 frequently. It was further alleged that the petitioner held wine parties with his friends and other persons at night, and the respondent number 2 was directed to serve wine to his friends, and the party would go on till 2:30 to 3 a.m. the next day. Also, it was further alleged that the petitioner herein had demanded that the mother of the respondent number 2, who was a pensioner, to deposit her pension amount with him and further that she, although had conceived several occasions, but the same was aborted by the petitioner against her will. Also, it was alleged that on 10/1/2005, the accused had demanded from the respondent number 2, the petitioner had demanded from the respondent an amount of rupees 25,000 bracket or Kuriba, which she was to bring from her widowed mother. On the respondent number 2 denying to ask her mother about the said amount, it was alleged that the petitioner had beaten her mercilessly and driven her out of the house by keeping all her ornament, dresses, etc., which was projected to have been received by her at the time of her marriage. So the respondent number 2 further alleged that, left with no other alternative, she started to live and reside with her widow mother at Bongaigaon. Also, she also projected that she had filed a maintenance case before Court of the Learned CJM, Bongaigaon, which was stated to be pending. Basing on the same, she demanded action against the petitioner herein. Police, on receipt of the said FIR, registered the same as Bongaigaon PS case number 232/2005 under section 498 bracketed A IPC. Also, on conclusion of the investigation, the police submitted charge sheet against the petitioner herein under section 498 A IPC. The petitioner, having pleaded not guilty to the charge so framed against him and having demanded to be tried, a trial commenced in the matter. Also, the prosecution had examined 5 witnesses in support of its case, and the statement of the petitioner herein was recorded under section 1313 CRPC. So no defense witness was adduced by petitioner herein. On conclusion of the trial, the learned trial court proceeded to convict the petitioner herein under section 498A IPC and sentence him to undergo simple imprisonment for 3 months and to pay fine of rupees 1,800 in default, to undergo simple imprisonment for further 1 month. Also, the petitioner herein being aggrieved by his conviction by the learned trial court, assailed the said judgment and order dated 19/9/2011 before the session judge Bongaigaon. The said case was transferred to the court of the additional session for disposal. The appellate court, upon considering the matter and on hearing the learned counsel, upon appreciating the learned appellate court, upon appreciating the evidences coming on record as well as the submissions advanced 19/6/2013 to dismiss the said appeal, upholding the conviction of the petitioner herein by the learned trial court. Being aggrieved, the petitioner has instituted. Also, Mr. R.J. Burwa, learned additional public prosecutor, has submitted that the evidences coming on record during the trial without any ambiguity indicated the commission of torture and assault upon the respondent number 2 here by the petitioner. He submits that. What is the exception, Mr.
Act which is of such a nature as is likely to drive the woman to commit cause grave injury or danger that attacks in this case the woman, or harassment of the woman where such harassment is with her or any person related to her to meet any unlawful demand on account of failure by her or any person related.
Mr. Burwa, by referring to the evidences coming on record, has submitted that the cruelty as committed upon the respondent number 2 by the petitioner is proved beyond reasonable doubt. He submits that the provisions, that the ingredients of section 498A has been established beyond reasonable doubt by the prosecution matter against the petitioner. Also, he submits that the conviction of the petitioner by the learned trial court being so based on the materials, on the evidence, based on a proper appreciation of the evidences coming on record in the trial, the same would mandate no interference from this court. He further submits that the learned appellate court had, on appreciation of the evidences coming on record, arrived at a conclusion that the conviction of the petitioner herein would require no interference. He submits that the said conclusion being so based on a proper appreciation of the evidences coming on record in the trial, by the appellate court, the same would also not mandate any interference from this court. I've heard the learned counsel for the for the state and peruse the materials available on record. Also, for a proper appreciation of the conclusions reached for the proper appreciation of the R.J. Burua, learned additional public prosecutor, also the conclusions drawn in the matter by the learned trial court as well as the appellate court, the evidences adduced by the parties before the trial court is required to be noticed. Also, PW1 Osim Bhachaji, who is a neighbor of the husband of the petitioner, herein, had deposed that in the year 2004, the petitioner and the respondent herein were deposed that the marriage of the petitioner and the respondent herein was solemnized as per Hindu religious rites, and further that the marriage was also registered and he was a witness to such a registration of marriage. The marriage certificate of the petitioner and the respondent was exhibited by him as Exhibit 1. He further deposed that for about 1 year from the date of marriage of the petitioner and the respondent, they had lived peacefully. However, thereafter he started to hear halla in the house of the accused during the night time. He further deposed that the petitioner herein had illicit relationship with other women, and he was also caught red-handed in the matter. He further deposed that the petitioner was also was arrested by the police. Also, the PW1 testified that the petitioner herein had demanded rupees 25,000 from the respondent number 2 and had tortured her physically for the purpose. PW2 also deposed that the petitioner herein had brought home different women, and when the respondent number 2 herein had raised objection, he used to assault her. He further deposed that the petitioner herein had driven away the respondent number 2 out of his house. However, in his cross-examination, PW1 revealed that he did not see the incident. PW2 is the respondent number 2 in the present. She, after deposing about the factum of her marriage and also its registration under the Special Marriage Act, had deposed that after 4/5 months from the date of their marriage, the accused used to bring his friends and other women to their house and used to drink wine with them. She further deposed that he had, and when she protested, the petitioner herein used to assault her, which had also resulted in bleeding from her nose. She further deposed that she was confined inside a room and was not given food on several occasions. PW2 further deposed that she was pregnant with his child, but the petitioner had forced her to abort the child. Also, he deposed that unable to bear the torture of the accused number, she had come to her maternal home. Also, she further deposed that the petitioner herein came to her maternal home and demanded 25,000 as dowry, and had stated that if the respondent number 2, if the PW2 did not meet his demand, he would not take her back to his house. Also, the Respondent number 2, PW2 further deposed that the petitioner had deposed that the petitioner herein had kept another woman in his house, and the incident was reported on 16/9/2005 in the first page of a Bengali news daily, apostrophe, Dainik Jugantar. Also, during her cross, the petitioner could not remember the dates on which the respondent could not remember, the number 2 could not. During her cross-examination, PWD2 deposed that she could not remember the dates on which the petitioner had demanded money from her, and also the dates on which she is to bring woman. PW3 next is the mother of PW2, and after reiterating the factum of marriage of the PW2 with the petitioner herein, she had deposed that the petitioner had tortured PW2 and had also confined her inside the house, and had not given her food. The PW3 further reiterated the fact that the petitioner herein used to bring his friends to his house and he used to get drunk with them, and that he even forced the PW2 to have wine with them. PW3 further deposed that the petitioner herein had brought other women to the house and he had illicit relationship with them. And when protested by the PW2, he used to assault her. PW3 further deposed that once when she had come to the house of the accused, she saw the accused petitioner drinking liquor with his friends. And when she had resisted, she was asked by the petitioner herein to take away her daughter, bracketed PW2, with her. Also, she further deposed that unable to bear the torture, PW2 left her matrimonial house and took shelter in her house. The PW3 also deposed that the accused came to her house and had demanded 25,000, with further stipulation that it only on fulfillment of his said demand, he would take PW2 back to his. PW3 deposed that she could not fulfill the demand of the accused person. PW3 during her cause submitted, deposed that she had not seen the incident of assault upon the PW2, but was told about the same by PW2. Also, PW4 is the neighbor of PW2, and he also deposed with regard to the factum of marriage of the petitioner and the respondent number 2 herein. He further deposed that after the marriage, the petitioner used to bring home other women, and on this matter, frequent fight between PW2 and the accused and the petitioner had occasioned. He deposed that the petitioner herein had beaten the respondent number 2 and had driven her out of this house after about 1.5 years of their marriage, and PW2 had taken shelter in her maternal house. PW3 also deposed that the witness, that the petitioner was caught red-handed with another woman from his house and was handed over to the police, and the matter was reported in the newspapers. In his cross, PW4 deposed that after PW2 2 had after the respondent number 2 had left her matrimonial home, she had stayed with her mother in his rented house. PW5 is the investigating officer. He exhibited the charge sheet. So, during his cross, approve the charge sheet. Approve the charge sheet. During his cross-examination, PW5 deposed that the respondent number 2 herein had not stated before him the date when the accused came to her mother's house and demanded money from her. Also, on an examination of the said evidences coming on record, the learned trial court had drawn the following conclusions. Para 10, 11, 12, 15. Also, on a perusal of the set conclusions drawn by the learned trial court, this court finds that the same to be so based on a proper appreciation of the evidences coming on record at trial. As noticed herein above, the prosecution witnesses had adduced evidence which revealed about the torture committed upon the respondent number 2 herein by the petitioner, and also about the demand of dowry by the petitioner. Also, accordingly, this court is of the considered view that the conclusions drawn by the learned trial court would not mandate any. Accordingly, this court is of the that the conclusions drawn by the learned trial court in the evidence in the judgment and order dated 19/9/2011 is not erroneous. Also, accordingly, the conviction of the petitioner herein by the trial court under section 498A IPC and the sentencing as ordered would not mandate any interference. Also, having drawn the above conclusion, this court would now examine the judgment dated 19/6/2013 passed by the Court of the Learned Additional Session Judge FTC Bongaigaon in CA number 31/4 bracketed 4/11. On a perusal of the said judgment, it is found that the learned appellate court had appreciated the evidences coming on record, and on such appreciation had concluded that the findings reached by was not reached by the learned trial court did not suffer from any infirmity, and accordingly proceeded to dismiss the appeal. Also, the conviction of the appellant being about the petitioner being under section 498A, the same would mandate a consideration. The same would mandate to be noticed. Accordingly, the provisions of section 498 is extracted here in below 498. Also, on a perusal of the said provision, it is seen that the same mandates that whoever, being the husband or the relative of the husband of a woman, subjects such woman to cruelty shall be punished with imprisonment for a term which is 10 to 3 years, and shall also be liable to be fined. The term apostrophe D, cruelty has also been explained to mean therein any willful conduct which is of such nature as is likely to drive the woman to commit suicide or to cause grave injury or danger to life, limb, or health, bracketed whether mental or physical of the woman, or the harassment of the woman where such harassment is with a view to or any person related to her to meet any unlawful demand of any property or valuable security, or is on account of failure by her or any person related to meet such demand. Also, on a perusal of the evidences brought on record by the prosecution witnesses in the trial, it is seen that the torture upon the respondent number 2 by the petitioner herein is proved beyond a reasonable doubt. Further, the illicit relationship maintained by the petitioner herein with other women is also established. Also, the same would go to show that in addition to the physical torture as committed upon the petition, upon the respondent number 2 by the petition, she was subjected to mental torture as well. Also, further, the evidence of PW 1, 2, further, the evidence of PW 2, wherein she had deposed that the petitioner herein had demanded 25,000 as dowry from her, is corroborated by the evidences of PW 1, PW 3, and PW 3. Also, accordingly, the demand of dowry and the harassment caused to the to the respondent number 2 on non-fulfillment. Accordingly, the demand of dowry by the petitioner and the consequential harassment caused to the petitioner herein on account of non-fulfillment of the said demand is established beyond a reasonable doubt. So, in view of the above conclusions, this court is of the considered view that there exists no infirmity in the judgment and order dated 19/9/2011, passed by the learned SDJM, Subdivisional Judicial Magistrate, bracketed S. Bongaigaon, in GR case number 346/05, and the same would mandate no interference. Consequently, the judgment and order dated 19/6/2013 would pass by the appellate court in CA number 31, in case number CA 31 bracketed 411, would also not mandate any interference. Also, accordingly, the present criminal revision petition is held to be devoid of any merit, and the same stands dismissed. The appellant, the petitioner (accused) is directed to surrender before the trial court to serve out the sentence. The appellant shall surrender before the trial court within a period of 1 month from today. So, with the above observations, and directions, the present appeal stands dismissed. Anything more to be added? Nothing? This matter, agor file to some. एकदम The present revision was listed on 26/9/2024. However, there was no representation on behalf of the petitioner on that date. Today, when the matter was received, was listed, was called upon in the first half, there was no representation. Accordingly, the matter was kept to be considered in the second half. When the matter was again taken up in the second half, there was no representation on behalf of the petitioner. Accordingly, this court proceeds to consider the present criminal revision on its merits, basing on the materials available on record and after hearing the learned additional public prosecutor. নাম গীতা লিখিলে নহয়? Oh, the interim order passed, the interim directions passed by this court. Court লিখিব নে? There was no interim order.
Outside, my lord, 3 months.
There should be something. Belligny. It was on. The interim directions passed by this court-wide order dated 17/9/2013 in criminal MC number 718/20 stands vacated. Send down the records of the matter to the learned trial court forthwith, along with a copy of this order for information and yes, what do you have to say?
Yes, madam, first it came as a and in the order, earlier order.
No, it's not there. Bhim Singh. Oh. He was not granted any bail, so he might have completed that state period. Three years. Is there any interim here? Hey, if he is on previous bail also, that bail has to be approved by this court in the present proceeding. This is any, sir. Hey, this is lying like this. Huh? Do it. It is seen that there was no order passed by this court suspending the impugned judgments, by suspending the sentence imposed by the trial court as well as the appellate court in the matter. So the penalty, the punishment, the sentence, the petitioner hearing was convicted under section 325, 324 IPC and sentenced to undergo imprisonment for 3 years and to pay a fine of rupees 10,000. So they set conviction and sentencing was so done wide judgment and order dated 24/5/2012 passed by the Court of the Learned Chief Judicial Magistrate Nagaon, Assam in GR case number 452/. So the set sentencing of the petitioner was suspended by the appellate court on an appeal being filed in the matter by the present petitioner. So the said appeal being criminal appeal number 41 bracketed N 2012 was dismissed by the Learned Additional Session Judge Nagaon wide judgment and order dated 30/10/2012. So thereafter the present revision petition was instituted. So a perusal of the order sheets in the present proceeding both does not reveal that any interim direction was passed towards suspending the sentencing of the petitioner by the Learned Trial Court as well as by the appellate court in the matter. So accordingly, it is not known as to whether the petitioner has already undergone the sentence as awarded to him in the matter. In view of the above, Mr. M.P. Goswami, Learned Counsel for the Learned Additional Public Prosecutor appearing for the state respondent submits that he would receive his on the next date of listing. When? You give me a date. Accordingly, registry to list this matter again on
next Wednesday, madam.
On Wednesday next. Tarik ki manabu? 24/9/2025 as a top of the list item. Yes. Anything?
My lord, the W6, my lord, medical officer, this is a cartoon, my lord, and is on the head, my lord.
324/34.
That provision is, my lord, imprisonment and fine. So,
No, whether there is a or remain suspended. 324 is alternative. Or with fine.
Yes, or fine, or with both.
What are you appearing? E. Chakraborty. Dipanjan. E. Chakraborty, B. Sharma. None appears for the petition on call. They are full now today. They can't do anything more, Mr. Sharma. They have done their quota is over today. They all have enough. এইটো হোৱা নাই না এটা আছেতো তোৰ মাৰি খালি ইটোৱে আছে এতিয়া নেকি none appears for the petitioner on call. P. Sharma, learned National Public Prosecutor, is present for the state for the justice registered on Friday. Yes.
Order, my lordship.
Now I am in 324, 348, 498, IPC, CRPC, PC Act. The land will not go inside now. Yes, you are ready otherwise? As prayed for by the Learned Council for the parties, a registry to list this matter again after 2 weeks on a date to be fixed by it. The matter will not be treated as parted and or tied up matter with this court any further.
Highly obliged, my
50? Yes, where is Miss A. Gayan? Oh, that case. None appears for the petitioner on call. This matter was heard on 10/9/2025 and was fixed today and was fixed today to facilitate the Learned Council for the respondent number for the respondents to make his submissions in the matter. However, when the matter is called up, none has appeared for the parties. So, for the ends of justice, a registry to list this matter again on Friday. Friday. He'll say not. Because they made such submission, his records were not missing. He had to reconstruct, but today nobody is there.
Automatic.
But anybody had appeared? Nobody had appeared in 46, I suppose, no? Alam, where is he? Hey, Suti also.
Yeah,
Okay.
yeah.
Things that 140 Probation Act will Probation Offenders Act will appear here, apply here also, Special Act also. No problem. What is that? After when was the incident? Two 2006. 19 years. Not a fit case. But the parties at some length registry to list this matter again on Friday. We'll dispose it off on that day. Yes, Mr. Mojumdar. Disposed of. We'll give you a probation. Conviction maintained. Probation. Not go to jail. But don't hit your relatives again. Yes. You had appeared in the matter last day.
But I Hazurika appear.
I Hazurika. Namgita Likilo. I Hazurika. Oh, that case. Due to paucity of time, the order could not be delivered today. Raised it to list this matter again on Wednesday next.
Next was
Wednesday.
next.
No.
Okay.
Paucity of time, the order could not be passed today. Registry to list this matter. Very good idea. Disposed of. We are giving her the relief. Disposed of day. Muk diri bo. Due to paucity of time, the order could not be passed today. They are a little bit tied up. This will require a long order. We'll pass it before the vacations, don't worry. Tuesday will go, idea. Mr. Islam, we are passing your orders, but you will get it by latest by Friday or not before that. Rokiba? Ito apna